Hello and welcome back. This is Roger Royce, host of the 10,000 Startups podcast, where every week we bring you an interview with somebody in the legal industry to discuss issues of interest to startup companies. This week we have a guest. This is a little bit different this week. We're going to talk a little bit more technically with Eric Goldman about an issue very specific to trademark infringement. So we're drilling down a little bit more than we usually do. But I think this is important to you, even as a startup, especially if you're doing any sort of B2C business and any sort of international business, and especially if you're involved in something that's pretty trademark heavy. Eric is a professor at Santa Clara University School of Law. He is also the Associate Dean for Research, co-director of the High Tech Law Institute, and supervisor of the Privacy Law Certificate. He focuses on internet law, intellectual property law, advertising, and marketing law. So welcome, Eric. Thank you for being here today.
Oh, my delight. Thanks for having me.
So I know we're going to talk about the SAD cases, which is a term I think you invented, the Schedule A defendant cases. And before we get into that, just so everybody understands the issue, maybe you could kind of tee up why trademark infringement is such a problem for plaintiffs when it comes to online marketplaces like Amazon, et cetera.
So let's talk about online marketplaces. The general theory is that the marketplace can throw open its doors to vendors who have access to products that others don't, or who have unique ways of marketing the items that they have. And in theory, then the invisible hand of the marketplace sorts it all out. As we know, however, and we've seen over and over again in the online context, that if the doors are open for merchants to come through and sell their wares, some of them will not be legitimate. And there's a variety of ways that illegitimate vendors can engage with consumers. Sometimes they're selling misrepresented goods. Sometimes they're selling goods that are pernicious or even harmful to the buyers. And sometimes they're selling goods that are misbranded. They're claiming to be the item of a well-branded product that people know, but aren't actually that. And online marketplaces then create a fair amount of policing work or quality control work on the part of the trademark owners to identify these items that are misportraying themselves as being the brand owners and potentially harming consumers either physically or at least in diverting their sales. And because there's so many online marketplaces and online merchants, this is a significant challenge for trademark owners.
Yeah, especially internationally, I would imagine, just because of the jurisdictional issues, just trying to identify who the infringer is, et cetera, probably is just 10 times worse now than it was before if there were online marketplaces.
Well, especially in China, as we know, that there's a lot of Chinese entrepreneurs who don't necessarily adhere to U.S. standards of business practices. And to the extent that they're given access to global marketplaces, then some of those merchants may not be the best options for consumers. And the marketplaces either clean them up or they let them sell, and then buyers learn about the problems.
Yeah, so I've had limited experience with this, but I have had one experience. Anecdotally, I think it really sort of illustrates the issue that I want to share with you. Is many years ago, my client, a U.S. person, was selling these battery chargers, and he sourced them in China, and he put up his own website, so he didn't use an Amazon. I think it was before Amazon, and he posted an ad: "Buy my battery charger," and he sold exactly one. For about $12, I think. And the party he sold it to was the plaintiff. And the next thing that happened is he got served with a summons and complaint because they couldn't get the manufacturer in China that was infringing. So they got my guy, the U.S. person. And that was the start and end of his business. It cost that plaintiff a fortune in legal fees, of course, to shut him down, which seemed a little silly to me because we didn't even know it was infringing. So now just multiply that with Amazon times 1,000, right? Because it's so easy for people to do that. So I think that kind of tees up the problem. So tell me what the solution here is that we've seen pop up that you've written about.
So historically, in a circumstance where there are vendors in the marketplaces selling items that may be infringing third-party trademarks, the system has been what's called notice and takedown, that the trademark owners would send notification to the marketplaces that this vendor is engaging in trademark infringement, and then the online marketplace would take down the infringing items, or in some cases, take down the vendor altogether. And that notice and takedown system is suboptimal, perhaps for everybody, but maybe optimal compared to the alternatives. So many trademark owners object to the notice and takedown because it requires them to keep sending these notices, even against people that they think are recidivists. And marketplaces and the merchants don't always love the takedown notices because many times trademark owners overclaim, and they will target vendors who are actually engaging in legitimate activity, and impose a bunch of risks and costs on the system by removing those items or marketplace vendors entirely. So in order to get around the notice and takedown scheme, some trademark owners have deployed what I call in my paper the SAD scheme. And SAD is an acronym for Schedule A defendants. What they do is that they find dozens or hundreds of marketplace vendors that the trademark owner thinks are infringing, and then they sue them all in a single complaint. So where it costs over $400 to file a lawsuit against a single defendant, the trademark owner spend the same amount of money to sue 200 plus defendants. So it reduces that enforcement cost that you were mentioning, just based on the filing complaint alone, or the filing fee alone. And then based on that complaint, they do a bunch of interesting things that we'll spin out in just a moment. But the thing that distinguishes these is that the complaints are filed where the defendants' identities are sealed. They're not disclosed to the public, which means the defendants don't get notified, even if they tried to find out if they've ever been sued, about the fact that there's a litigation taking place where their rights are being adjudicated. They're not told, and as a result, they're not going to be present when the major legal action takes place.
Can I pause right there for a second? Because that's the part that kind of confused me a little bit. Why would they seal it? Wouldn't you want the defendants to know? I mean, why is that such a big secret? And why would a court allow it?
Well, exactly. So in general, litigation in our court system is open to the public, and the presumption is that everything filed in a court case is available for public scrutiny. It's part of the way that we build transparency that is essential to accountability in our judicial system. So anytime there's some sealing of information, that's already an attack on the integrity and accountability of the court. So courts are generally quite resistant to it. But the argument that the trademark owners make is that if they don't seal the identity of the defendants will get wind of the lawsuit and they will destroy evidence or move property out of the reach of the judicial system. And therefore, before the trademark owner has a chance to actually vindicate its rights, the defendant will have made counter moves that will negate the case.
Is that a legitimate claim, do you think? Does that actually happen?
Yeah, there are definitely times that's legitimate, but there's a bunch of assumptions that built into that. For example, that the defendants are actually going to make those counter moves. And so one of the cases that recently came out, the trademark owner claimed that they were concerned that the defendant would move the property into a foreign jurisdiction and therefore get outside the reach of the court. But the defendant was based in Connecticut, and there was no evidence that they had any foreign accounts of any sort or whatever. And so the court's like, you're claiming that this party is likely to move the money out of the reach of the court, but what evidence do you have to support that? And the trademark owner had none. They just said, but we want this right to seal the case without actually having the evidence to back it up. And those are the kinds of mistakes that we see in cases like this.
Yeah. What do you think is really going on? Like in a case like that, you know, where they're really, I mean, you're right, he's in Connecticut. Where are they going to go? Right. What's the real?
Well, so one thing that could have gone wrong there is that they just didn't do their homework. They literally didn't do the groundwork. They claimed that they had done their homework, but they never actually did. Another scenario is that they just made a mistake. That they thought they had all the facts lined up and they just actually didn't. But the reality is that very few of the trademark owners who are pursuing this type of litigation actually get punished for making mistakes. And so they're like, we're suing hundreds of defendants. We're going to bat 99%, not 100%. So of course there's going to be a couple of judgment calls, mistakes, whatever. But look, hey, we got 99% right. Give us credit for that. That's not the way the legal system works. But sadly, I see judges are open to that kind of argument.
Okay. And before we leave it, one other point she made is just the cost savings. What does it typically cost to sue somebody? If they're to sue one plaintiff, the filing fees they're expensive. They're hundreds of dollars, right?
Yeah, filing fee is $402 in federal court. But that's actually just the tip of the iceberg. Of course, there's the drafting of the complaint, there's doing the pre-filing investigation. So just to get to a complaint, I don't know what you would quote, but I would expect there would be very few lawyers that say less than $15,000, and the number might actually be higher. And then, of course, if you actually have to litigate against a defendant, easily we're looking at $100,000 plus to reach some kind of outcome in federal court. And if you're suing 200 defendants at the same time, and if it costs that same amount, the way that they do it, they cut corners. But if you can get 200 defendants for the price of that one, well, you can take that $100,000 and all of a sudden it comes down to, help me do the math, I think that's $500 each. And so all of a sudden now zones of settlements become much more realistic that would not have otherwise been realistic if you were doing one by one.
Okay, well, that certainly tees up the problem, right? I mean, it's a prohibitive cost of litigation, and plus, basically potentially slippery defendants that you're not going to be able to enforce judgments against anyway. So now here's the solution, and you've heat up the solution now, a complaint with an attachment of hundreds of defendants that is sealed. So what is the problem with this? Why is this a problem, would you say?
Well, let's talk about then where the payload comes, because that exposes the problem. So the idea is now we've got a complaint on file that sues, let's say, 200 defendants, where normally they would have sued one, or they would have sent notice and takedowns and never have gotten into the litigation altogether. What the plaintiffs then do is that they seek an ex parte TRO, or temporary restraining order, which is a extraordinary relief that courts make available to create short-term freezes in activity until there's proper notice and the case can proceed on a proper path. If the trademark owners get that ex parte TRO, they present them to the online marketplaces. They say, we want you to freeze this vendor's ability to sell, and we want to freeze all the cash they have in their account. And although it might be temporary, the online marketplace may never lift that freeze. They may treat that as permanent until the court gives them further instructions. And so as a result, what happens is immediately these vendors are blindsided. They have no idea that they've even been sued. And all of a sudden they can no longer make sales. They have no more revenue or profit that they're generating. And the cash that they have in possession of that marketplace has now been frozen. So they lose their cash flow. And so the combination of those two effects immediately puts defendants in the position where they got to settle. They have to settle or else their business is dead in the water. And it's that abuse that's the real problem. It's not that they were sued in secret. It's the fact that then this ex parte TRO acts as a dispositive legal consequence when it's supposed to only be a way of freezing matters until the court actually makes an adjudication. And the fact then that the online marketplace has imposed this freeze then ends up working substantially to the benefit of the trademark owners.
Okay, so it's a matter of leverage, it sounds like to me. And litigation is really a stage of settlement negotiation in my mind. And now you've shifted the leverage tremendously to the plaintiff in something like this. And in your view, unfairly.
Yeah, and let's talk about that leverage. So, for example, assume that there's a vendor who's selling 1,000 different items, and only one of them is trademark infringing. Let's just assume that for a moment. the freeze will affect the entire 1,000 items. So it's not only stopping the sale of the infringing item, it's stopping the sale of hundreds of others of legitimate items. And the cash freeze then freezes all of the money, not just the money that's attributable to the infringement, but all these non-infringing sale proceeds as well. And so it's extraordinary leverage and completely inappropriate leverage because it's using freezes on non-infringing items to extract concessions on what might have been an infringing item. That's assuming the item's even infringing. Remember, that has not been proven yet. In some cases, it might not be proven. But even if that was true, you can see how that gives too much leverage in the hands of the trademark owners.
Yeah, gotcha. Let me shift gears a little bit, because the other question that kind of comes up when I hear this is just the jurisdictional aspects. And for our audience, our non-lawyer audience, jurisdiction is just the idea that a court will basically assume the power to hear a case, that there are sufficient contacts between the defendant and the jurisdiction, which is the place basically, or the place under the court's control that they're hearing the case. So if we have a Chinese seller and they sell a product that ends up in the US, is that enough for a court to assume jurisdiction and actually hear this case?
So this is one of the ways in which trademark owners also cut corners and obtain leverage that they're not entitled to. They do have to show that the US courts have jurisdiction over defendants. Often the Schedule A listed defendants, the one that's sealed initially, doesn't provide any detail about the location of the defendants. It simply lists their name, the account name in the online marketplace. So the court gets no facts showing that there's some reason to assume that there's jurisdiction in the United States. And then, of course, even where the particular court's being held. And the trademark owners will use a bunch of arguments to try and overcome that. They'll say that the online marketplace was in the US, or they'll say that there were sales in the US, or they'll say even that they did a test buy where the plaintiff made the purchase like you described in your circumstance, and that might be the only sale in the US. And they'll use those as examples of why jurisdiction would be appropriate in the US. But because the defendants don't even know that the ex parte TRO is being considered, they're not around to raise a jurisdictional objection. So as a result, the court will accept the trademark owner's assertions that are uncontroverted. And as a result, we don't really get that jurisdictional question tested.
I see. Okay. And are some courts more friendly to these sorts of claims than others?
This practice is predominantly taking place in the Northern District of Illinois, the federal court system that covers the Chicago metropolitan area. It has shown up in other jurisdictions, but at a much lower rate. And even though it seems like a regional problem, as long as it keeps working, as long as it keeps working, trademark owners are going to keep going there. So it's really become a substantial percentage of the overall quantity of IP litigation taking place in the United States is now taking place in these Schedule A defendant cases, these sad scheme cases I describe them, and they're taking place functionally outside of public purview because of the fact that they're sealed. So we don't even really know what percentage of cases are being heard using this mechanism, but it's become a critical part of the overall litigation environment.
I see. Okay. What's I guess what would be your solution to this problem? Is this something that requires I guess judicial action, statutory, congressional? Is there a solution? Is it just one of those glitches of the US legal system that we live with? Or is there something that that you would like to see happen in this case?
Yeah, the simplest thing would be to have judges enforce the law as it's already written. You mentioned, for example, the jurisdictional question. Judges could push back on the trademark owners who are making these claims and say, I need more evidence of what you're giving me. I can't just accept as bare representation. Show me that these particular defendants are eligible for jurisdiction in my courtroom. But they're not doing that. So if judges were to be more aggressive on the rules that are in place and making sure that the trademark owners have complied with them, I think that this problem would largely go away. And yet, I don't know that we can rely on judges to do this, because in the Chicago metro area, all the federal judges have heard many of these cases, and they've heard many complaints from defendants who are wrongly named in the lawsuits. And yet the judges keep proceeding as if this is a normal accepted practice. And so I'd like to educate judges. I'd like to think that would fix the problem. That may not be enough. If it's not enough, then we need to do more. And that might be a statutory intervention, which sounds really painful because it's so hard to get any new law passed. And part of the way I'm hoping to do that is through evangelizing these concerns, highlighting them, because I think once we start talking about that, I think people are going to realize this is not the way we want our court system to work. And there will be a reconciliation, whether it's through judges or through legislation, there will be a reconciliation when people realize what's going on in our courts.
Gotcha. One other thing I just want to highlight before we leave it is in your article, you talk about how some of these defendants are identified through a pretty simple search function that might not even, and you give a pretty good example in the article where it had nothing to do with trademark. It was just language used in the description of the product. Do you recall that?
Yeah, I think it's worth highlighting just so people get a sense of the scale of how weird these cases look. One of the frequent users of the SAD scheme is a company called Emoji Co. And they claim a trademark in the word emoji for a long list of products that they attempt to license. Onto Amazon, they search for any listing as word emoji, and they claim that that's infringing. So even if the item displays an emoji, and the only way to tell consumers is that there's an emoji on that item, the Emoji Co search would reveal that as an alleged infringer. They would go on to the SAD scheme complaint. The judge would never hear from that vendor in all likelihood before the ex parte TRO is issued. And as a result, those vendors are going to be ensnared in this net of just picking up everyone who's using the word emoji to describe their products.
Yeah, I see. Yeah, interesting. And I guess the last thing for our audience who are a lot of entrepreneurs and startup companies, I guess the best way when people come to me and they say, gee, how do I avoid litigation? How do I not get sued for doing X? I say, don't do X. So it sounds to me like there are more tools now in the arsenal of rights holders, and that people who are engaged in an international or even domestic B2C business should be just especially careful about infringement issues now. That's sort of my takeaway. Should I have another takeaway for the audience?
Yeah, I do think that is only part of the way of analyzing the issue here. Go back to the emoji example we just gave, where someone wants to sell a product that has an emoji depicted on it, and they want to tell the public that there's an emoji on it. I don't think it's reasonable to say, don't infringe the trademark rights of the Emoji Co, because they literally don't have any trademark rights, but they're still at risk of being ensnared in this. And that's where I do think that it's helpful for your listeners to do two things. One, to recognize that though they might be trademark owners and interested in stronger trademark rights to help enforce their rights as plaintiffs, they need to recognize that there's always this risk of abuse of it coming back to be wielded against them. And so trademarks need a balance. And I think that it's helpful for the audience to recognize, like, we're not just talking good guys and bad guys. We're talking about a much more complicated system where we're talking about the fact that the people we thought were the good guys and trademark owners are actually acting as the bad guys here. The other thing I would do is that for anyone who does get ensnared in one of these nets, is at minimum to help enlist the attention of their elected members of Congress, to tell their members of Congress, look, I am experiencing by my business distress because of the fact that trademark law is being wielded against me in an inappropriate way. And until members of Congress realize that that this is going on, they don't think there's a problem. But when businesses are in fact affected, they need to speak up. And it's been really unfortunate seeing how many businesses just are being disregarded for the fact that they're victims of a scheme that should never been wielded against them.
Gotcha. Okay. Well, with that, I want to thank you, Professor Goldman, for being here and discussing this with us, highlighting the issue, explaining. It's really fascinating. It's interesting, and there are some good lessons in there, good practical lessons for people to take away. So thanks very much. This is Roger Royce. This is the 10,000 Startups podcast. We come to you every Monday with a new issue of legal significance to startup founders, and we will see you all next time.